immigration attorney Moumita. I'm coming to you live to talk to you about immigration and to see the questions that you have on your mind today. Thank you so much for joining me. My name is Moumita Rahman, and I'm an immigration attorney. I have been practicing immigration law for the past 15 years, and it is my pleasure to do the work that I do because I believe that immigrants make America great already. So thank you so much for joining me. Welcome to my channel. If you are a current client, thank you for trusting us with your case and for being here today. And if you are a viewer or somebody who's watching us for the very first time, welcome to my live. And I'm going to go ahead and talk about immigration questions, and I will do my best to answer as many questions that I can during the time that I have before I leave. So welcome. And I want to start off by talking about some questions about VAWA cases that we received at our office over the past few days. And these are very important because, as you know, if you are an immigrant who is married to a US citizen or to a green card holder and you are suffering in your relationship, either your spouse filed for you, but now they're playing games and they don't want to finish your process, they're threatening you with divorce, or your spouse may be just refusing to file for you altogether, you may be thinking that there's no hope and you might be worried that there are no options for you. However, the reality is that when you are in a situation like that where your spouse is threatening to divorce you, threatening to call immigration on you, controlling every aspect of your life, making you miserable, and basically they are the ones trying to control whether or not you get a green card. And in fact, you may have even been told by your husband or by your wife that I'm not going to help you with this process because as soon as you get a green card, you're going to leave me. If you have been told things like that or you're dealing with stuff like that, then you should know that filing a self-petition underneath the law of VAWA may be a right that you have. And if it is a right that you have, you may want to consider pursuing it because these days, without having any legal status or not having hope of it, can be devastating. And it is important to know that VAWA is based upon law. So we've gotten a lot of questions in our office asking, well, what's going to happen to VAWA? Is it going to go away right now that Trump is president? And the answer is no, because it's still the law. It is basically law that was enacted and signed. You know, it was it's a statute. It's a statute that has been passed by Congress. It is a well-respected law that has been in existence for quite some time, and it's something very popular that is not just going to go away because it helps protect people. So if you are an undocumented immigrant married to a citizen or to a green card holder and you're suffering, this is something to look into, and we would be happy to hear your questions to see if you qualify. Please give us a call, 212-248-7907. I have some questions here from Cielo Beltran. Can I marry my boyfriend while I have a VAWA case pending due to abuse? We got divorced 2 years ago. From Cielo Beltran. Cielo, this is a great question. Can you get remarried while your VAWA case is pending? And the answer is no. If you get married to anybody else while your VAWA is still pending before your I-360 is approved, you will basically invalidate your eligibility for VAWA. So the general rule is that do not remarry anybody until you have received approval of your I-360 application, okay? Now, we got some questions at the office last week about somebody asked, can I file a VAWA even though my spouse is the one that left me? And the answer is, let's talk about this. If you are married to a citizen, if you're married to anybody and your spouse leaves you, if your spouse just up and abandons you, can you file for VAWA based off of that, even if they're the ones that left, or do you have to be the one to leave the relationship in order for VAWA to work? Well, guess what? Spousal abandonment is a form of emotional abuse. Hear this again. If your husband or your wife gets up and leaves you and just up and leaves you, they don't discuss anything with you, they don't file for divorce, they just get up and leave you, they walk out the door without a word, that is considered to be abandonment. And that can qualify as part of a pattern of emotional abuse against you. Now, what are some other things that we see? Well, sometimes if your spouse gives you the silent treatment, if they punish you, but you don't know what you did wrong, and they punish you by not talking to you, they disappear for weeks or months, and they don't tell you where they are. This is all usually part of a pattern that I have seen of emotional abuse. But the reality is that a lot of people will look at these like ultimate signs and think that, oh, now I can file for abuse. But the reality is that a lot of times, in the majority of cases, you're already feeling the effects and you're already seeing the smaller signs of abuse, of emotional abuse, before it gets the big thing. Except most of us are living in denial, right? So if your spouse is constantly putting you down, they make little comments that insult your intelligence, or they make little jokes suggesting that you're not that smart because you're from a different country, or because you're of a different race. They make fun of your religion. They start calling you names, right? Sometimes maybe a nickname can start off as like something fun, but then it quickly turns derogatory, right? They humiliate you in public. They raise their voice at you in public. They scream at you, or they scream curses at you. These are all little things that can happen. Like you're basically, ask yourself the question of, are you, do you wake up in the morning with knots in your stomach, afraid of making your spouse mad, right? You're afraid of how they're going to react to something, and you're constantly living on edge. Well, the truth is that when you are an undocumented immigrant and you're married to a US citizen, you may automatically feel a little bit of imbalance, because you realize that your rights may not be as complete as theirs. But then when you add to that when you add to that pot that, okay, well, now I don't want to make them mad because they might do something against me, including revoke my application or not file for me, then you have the classic concoction of what makes for a VAWA case. Okay, and if you're in that situation, the bottom line is to not delay, because the truth is that things are probably not going to improve. And even if things improve for a short period of time, what usually will happen is you're just going to be living in fear of that next day, that next week, that next month, when you upset your spouse again, and then they go back to treating you the way that you thought they were going to stop, right? And just don't delay. You can give us a call to find out how long, to see whether you qualify. And our telephone number is 212-248-7907. And we had another question that was related to this, about like, what if things between me and my spouse were really bad before, and my spouse was abusive before, but they're not abusive any longer, right? They're great right now. They're not doing anything to me. Now let's pull that apart, because the reality is that when your husband or wife treats you a certain way, do they actually improve? Do their habits go out the window? And the answer is no, because this is all part of a cycle. It's part of a pattern, because in reality, they're just kind of like a ticking time bomb that's just waiting to go off the next time you upset them. So even if you suffered abuse in the past, what I do want you to know is that underneath the law, the law does not require that your abuse be ongoing. However, the reality is that when there is abuse, it never actually goes away. It's just lying underneath the surface, okay? And if you're in that situation, please don't delay. Give us a call, 212-248-7907, okay? I have Zenly. I'm a client of yours. My I-360 shows that correspondence was received and USCIS is refusing it. Okay, that's good, Zenly. I can't tell exactly which client you are, but that's really good. Let's see what other questions we have. I just got married to a US citizen. Can you help us to file? From Abby. Abby, give us a call, 212-248-7907. We are taking a limited number. So for those of you who have contacted us to do a joint marriage case, I know that you've been told before that we're not taking those cases, but I am happy to report that we're taking a small, limited number of joint marriage cases this month. So if you want to get on that calendar, give us a call ASAP, 212-248-7907, because we are going to have a cap on how many marriage cases we take this month. So don't delay. Jeanette, I have been here for 41 years. I have 3 sons born here recently, and I got married to a U.S. citizen. How long is the whole process now to get any type of work permit or green card? From Jeanette Lara. Jeanette Lara, thank you for the question. So here's the thing. If you have been here for a long time, if you've been here for 41 years, Janet, then I'm going to guess that one of the reasons why you don't have your status fixed yet is because you may not have a legal entry, right? So if you are currently married to a U.S. citizen, or if you have adult U.S. citizen children that could technically sponsor you, what's the process like, and how easy is it? How hard is it? How long does it take? Well, the truth is that we have to always start from the very beginning of your story to see how you entered the country, because how you entered the United States is going to govern what we can do in your case and how complicated things are going to be. So the number one thing is that if you did enter the United States with a visa, or you have an inspection into the United States with parole, or you were waived through the US, well, I'm not going to talk about the waive through entry yet because that's become a little bit more complicated. However, if you have basically a visa entry to the United States, or an advance or a parole entry to the United States, and you are now married to a United States citizen, or you have a adult U.S. citizen child who can help petition for you, your case is going to be very, very straightforward, much easier than everybody else's, and you are going to be considered an immediate relative who's immediately eligible to adjust your status. And we would file something called a one-step application for you, where we file both an I-130 and an I-485. And that process is taking approximately 8 to 12 months right now inside the US without having to leave. However, where it gets a little bit more complicated is even if you have a citizen child or a citizen spouse, if you do not have the legal entry into the United States, that is where things get more complicated, because the law cuts off a lot of ability to do the regular process for that. So what are some of the things that you might be eligible to do? Well, number one, if your spouse or child is part of the military, we could ask for something called military parole in place, which essentially kind of like erases, it converts that one illegal entry into a lawful entry for the purpose of doing a adjustment of status application. But just keep in mind that's only for one unlawful entry. If you have the permanent bar, then we can't do military parole in place to help you get a green card, okay? If your relative or a former employer filed an application for you before April 30th, 2001, then you may also be eligible to do something called Section 245I adjustment of status, which essentially converts that one unlawful entry into a lawful entry for the purpose of filing for adjustment of status. You still need to have somebody sponsor you, like a spouse or a child or a parent. I've done several of these where my clients, they came in the 90s, and like an employer filed an I-140 for them, or maybe like their uncle filed for their parent, and they're basically able to do Section 245I adjustment of status as a result. But also, that is only if you have the one unlawful entry. If you have the permanent bar, then that's not going to help. Similarly, if you are married to a United States citizen, you could do something called a waiver, which is the I-601, which does require you to leave the U.S. to come back. Now, if you have the permanent bar, the waiver is also not going to help, because once you leave the U.S., you're not going to be able to come back, because they're not going to grant you your visa at the consulate. But most people do not want to leave the U.S. So what we would look at in that case is to see what your marriage is like, because if you're married to a citizen or to a green card holder, if you're suffering any emotional abuse or physical abuse, again, these are just controlling behaviors. If your spouse is toxic, if they are controlling, they're jealous, they monitor your whereabouts, they make you call them, they accuse you of cheating on them all the time, or maybe your spouse is cheating on you all the time. Maybe they're doing that to you. Maybe they're putting their hands on you. Maybe they're threatening to put their hands on you. Maybe your spouse is threatening to take the kids away. Maybe your spouse is threatening to call immigration on you. Maybe your spouse reminds you almost every day that you're illegal and you better watch out and not make them mad. If these things are happening to you, then you may be eligible to file for a VAWA self-petition. And for the VAWA self-petition, you do not need to have a legal entry to the United States. And in many cases, even if you have the permanent bar, we may be able to help you get a green card in the US, okay? But next, what happens if you're not married to somebody, right? If you're not married to somebody and you have an unlawful entry, if you don't have any relatives to sponsor you, then are you out of luck? And the answer is maybe not, because there's another case that not a lot of attorneys look at. It is called the T visa. The T visa is something that I personally really love to do, because it is something that is underutilized across the community, and I wish more attorneys knew how to do it well. I would like for more attorneys to know how to do it, but I would also like them to do it properly and well. But a T visa, just think of it this way. If you have ever had any sort of work situation, if you have ever worked for anybody inside the United States where you were afraid of your boss, right? Your boss was controlling. They scream at you. They call you stupid. They don't let you take a break. They don't let you take lunch. They make you stay all hours. They don't give you safety equipment. They remind you that you don't have papers. They remind you that you need to do what they say because they know all the people in the industry, and you're not going to be able to get a job if you leave or if you make them upset. If your boss especially has threatened to call immigration or the IRS or any law enforcement on you, and you basically stay at your job and do everything they say, no matter what the harm is to you, then you may be eligible for something called a T visa. If you are undocumented and you are at work and your boss sexually harasses you, they touch you, they try to get sexual favors from you, they try to get you to go on a date, they touch you, they make you do things, these sorts of things, and you're afraid of your boss, you may be eligible for a T visa, okay? If you came into the country and you used the help of coyotes, of smugglers, and they kept you somewhere and they made you do work, you may be eligible for a T visa. If you are in a relationship with somebody, or you have a family member who treats you like a servant, who treats you like a slave, they make you do all the work, they threaten you with violence when you don't do the work that they tell you to do, you may be eligible for a T visa, okay? We have done hundreds of T visas for people in all sorts of industries, from people in marriages to just relationships to we've done T visas for people who who are trafficked by their uncle and aunt, brought into the U.S. by their uncle and aunt, by their step parents, people who worked in construction, people who worked in home healthcare industries, people who worked in like the nursing homes, people who worked in nail salons, in the beauty industry, people who worked in spas, people who worked in stores, people who worked in warehouses, people who worked on farms. We have done T visas in almost every single industry, because the reality is that when you are undocumented, you are already subjected to labor exploitation. However, there are a lot of people out there who, labor exploitation is basically they're just paying you low wages, right? That's not enough for a T visa. But there are a lot of bad people out there who take advantage of the fact that you may be undocumented, and not only do they give you low wages, but they threaten you. They harm you, they physically do things to you, and they take even more advantage of the fact that you're undocumented. Let's face it, it's bad enough that immigrants get treated so poorly in this country, but it's really, really terrible when you're working for somebody and they take further advantage of that to extract, like we are here, this country is just built on so much blood, sweat, and tears of immigrants, but people don't know exactly how much, because this sort of stuff is not talked about. And if you have been in that situation, or you have that your mom or dad probably has been, this may be a way out for them. Okay. 212-248-7907. Okay. The T visa acceptance rate has become very low. Will that affect new applicants from AFIFA? AFIFA, that's not actually true. I don't know where you're getting this from, that the acceptance rate has become low. They're still accepting applications and approving applications. During what stage of adjudication does the USCIS verify abuser's citizenship? During initial stage, before issuing prima facie or EAD? That's a good question, Simone. I would say they really, really verify it during the proper adjudication stage. For the prima facie, usually we have to give some sort of documentation, and a lot of times we're giving just the verification request, and we still get prima facie. So they really, really look at it more deeply after the prima facie has been issued. Okay. All right, guys. That is and hello, Jesus. Thank you so much. I appreciate that. I'm glad you got some help. So have you had 2023 VAWA approvals yet from Jesus? I think so, Jesus, although we actually, I believe we have. I don't have the exact data. Okay, so that's all the time that I have for today. Thank you so much for joining me. Thank you for following me and for sharing my lives. Please do me a favor. Please go ahead and share my videos with anybody you think it might help. These days, knowledge is even more important to share with the community, so that people know what their rights are, to people know what is available to them. I know it's extremely stressful out there right now. All I can say to you is to keep your head up high. You are worth it. I don't care what they say. We all know the truth of how much you contribute to the society and how important everybody here is. So don't let it get you down. Just try your best, okay? Keep your head up high because you do make America great already, all right? And that's it. My name is Moumita Rahman. Our telephone number is 212-248-7907. How long does a joint motion take to reopen a case in Texas? Click anywhere from 1 to 3 years at this point, okay? All right, with that being said, I have to go. Have a wonderful day, everybody, and God bless.